Today's topic is possession. My name is K. Umesh Rao. This subject is covered under jurisprudence. In this class, we are discussing the meaning of possession, kinds of possession, possession in law, and possession in fact, elements of possession, what is possessory remedies, and reasons for possessory remedies and proprietary remedies. The meaning of possession. What is the meaning of possession? Possessions means the physical control of a person over a thing. For example, I have a watch. This possession means it is a relationship between men and things. My relationship with watch, I am possessing it. The evidence of ownership also shows the possession. It gives right of ownership because I am having this watch. I have the possession. It means I am the owner of the watch. Possession of material thing is very, very essential in life. Human life is impossible without consumption and use of the material things. Food, clothes, everything you should possess, you should own. So possession must be respected and protected to derive material value. The origin of possession, when they started concept of possession, at the time of the Stone Age, there was no possession and no ownership. Only animal law was prevailing. Brutal force was used to get the food. The concept of possession crept in mind of the human beings at later stage. There was no family system at that time. Hunting and fishing were the only living sources of the man. He hunted, he fished, he possessed, and he ate immediately. And at the time of the metal age, man started to think, oh, this is mine, this is yours. So the idea of possession gradually changed into the idea of ownership, and idea of ownership started dominating. Man began to think and distinction between the possession and ownership. Then started some selfish people. They are tempted to prefer their own selfish immediate interest. Because my watch I am having, I am going in night. Somebody will come and snatch away my watch. It causes attack on something, creates violence and disorder. So, to protect the human interest, self-help and private defense are incorporated to maintain order and protection of rights. The possession of law means possession recognized by law. For example, I purchased a scooter, it is a de jure possession. Sometimes things which is lost in the possession of the owner. For example, I lost a ring, that means I lost possession of it, but still I am the owner of the property. Now, kinds of possession. There are different kinds of possession. One, immediate possession and mediate possession. Immediate possession is called direct possession. Possessor possessed the thing himself. For example, I purchased the book directly myself. I ride the bicycle myself. I own a house and I reside in it. It is all immediate possession. Mediate possession means is called, it is indirect possession. It means I have purchased book through other persons. I purchased a book through my friend. I send my servant on my vehicle to purchase vegetables. It is mediate possession. Next one is corporeal possession and incorporeal possession. What is corporeal means? Having body. Corporeal possession is the possession of material things like land, house, building, movable. These things can be seen and it is a tangible. Incorporeal possession means it is not material things or it is intangible things. It has no body. It cannot be seen. It is a possession of anything other than the object mentioned. For example, trademark and patent, copyright. Concurrent possession or duplicate possession. It means possession of a thing may be in the hands of two or more persons at the same time. For example, I may possess a piece of land. Another person has the right to walk on the same land to reach his land. This is called as duplicate possession. Constructive possession and derivative possession. Constructive possession is not actual possession, but it is a possession accepted by law. It is a possession in law. For example, delivery of keys of a building is a constructive possession. I am handing over the key of the building to my tenant. It is a constructive possession. Derivative possession means holder of the property is not the true owner, but he has interest in the property. With two essential elements, mental and physical conditions are satisfied. What is derivative possession? Holder of the property is not owner, but he has interest. For example, owner of a watch gave a watch to repair. He repaired the watch. Owner did not pay the repair charges. Owner, until the owner pays the charges, the watch repairer will have derivative possession. When the owner pays the charges, derivative possession ends. If the owner, he doesn't pay the repair charges, he takes away the watch from the repairer without paying charges, then what happens? He becomes guilty of offense of theft. He may be the owner, but he is a thief. Adverse possession means person occupies the land inconsistent with the right of the owner. It is actual possession he is possessing in the absence of possession by rightful owner without lawful title. Another main discussion topic is possession in law and possession in fact. What is possession in law? Means possession recognized by law. I went to bazaar, I purchased a scooter, I possess it. This possession is recognized by law. I purchased a house, it got registered in my name, I am a legal owner. It is a de jure recognition. Sometimes property is not in the possession of the owner, then also it is okay. But still it is recognized by law. For example, building owner rented his building to tenant. The building is in the possession of the tenant, but still owner is the de jure owner. I lost a ring. I lost possession of it, but I am the owner of a ring in the eyes of the law. Possession of fact. What is possession of fact? It is only actual possession. It is related to the fact. It need not be recognized by law. Mr. A stole my scooter. Scooter is in the possession of Mr. A. It is a possession, it is a fact, but it is not recognized by law. It is only de facto possession. Example, servant has possessed a cycle of the master. It is a possession of fact. Now, elements of possession. What are the elements of possession? There are two elements of possession. Mental possession, that means animus possidendi. and physical possession, corpus possession. So mental possession means mental aspect is called animus possessendi. Physical aspect is called corpus possessendi. For a valid possession, two elements are must. One of them can not form a valid possession. Now we will study what is corpus possessency. It means physically possessed. I am having possession. The possessor must physically possess the thing or property. He should have a power to exclude all other persons from the use of that material object. The law gives protection to the possessor. So mere intention is not sufficient. There should be a physical possession of the property. Sometimes what happens, possessions may be constructive also, because I have money in my almirah, I locked it, I am a faraway place from my house. In that case also, money in almirah is my house, is possessed. It is presumed to be under my physical possession. It is called constructive possession. Corpus possession includes protection to the property and secrecy of the owner. We keep jewelry in a bank locker with two keys. Here, property is with physical custody of the bank, but property belongs to those who keep it in the lockers. Corpus possession can be converted into ownership. So corpus possession includes reasonable self-help, because I go in a dark night, then thief comes, he threatens and he asks money in my purse. So then we can resist with the reasonable force, we can use it. Another condition is animus possessendi. Animus possessendi means I have an intention to possess a thing. Person who has a possession of a thing, he must be mentally prepared to have it, and he must exclude all others from disturbing him. Here important points are: animus possessendi means a strong desire to possess the property. Sometimes property is owned by one person and enjoyed by another person. Because house owner rented a property to the tenant. Creditor gave money to the borrower. This is the case. Sometimes the property is used and possessed by some others. Even then, two essential elements are present in the owner. In the case of servant or trustee or guest, they use the property, but the possession is in the hands of the owner. Property need not be specific here. Several books are there in the cupboard. One book is mine. I need not remember all the books' name and individuals. Possession is not necessarily a claim of right. For example, thief wants to possess the stolen property. His intention does not create any legal interest. Now, wrongful possession and possessory remedies. What is possessory remedies? Possessory remedies, it is those legal remedies available for protection of possession even against the true owner. For example, I am the owner of the property, but some reasons other person he has possessed it. In that case, it is the legal remedy available to the possessor of the property, protection available to the possessor of the property, even against the owner of the property, because he is in custody of the possession, he is in the custody of the possessor. It means wrongful possession or wrongful possessor has a right of an owner with respect to all the possessions, all the persons. See, wrongful possessor, he is better than the true owner. Possessor has put in advantageous position than others, sometimes even than a owner. Law says, he who is earlier in time is better in law. What is this rule? This rule is simple. Possessor, he may be a wrongdoer, yes, law recognizes it. If he is deprived of his possession, he can recover the property from any person. Because now he is possessing the goods and nobody can deprive of the possession from him. Possession is a good title against anyone who cannot show a better title, because now he is having the possession. If you want to claim, if owner want to claim, he has to show better title before the court. Even the true owner, he takes his own thing, he may be forced to restore the possession it to the wrongdoer. True owner is not permitted to set up his own superior title of it. Then what true owner has to do? He must give up his possession first, then proceed in due course for law for recovery of the things based on the ownership. He has to go to court. He has to prove that he is the true owner of the goods. The possessor shall be entitled to retain and recover his possession until the judgment is passed. So, what is the reason for the possessor's right? It discourages violence of self-help. Possession is prima facie proof of title of law, provides protection to all the persons to protect their property and persons. True owner is prevented to use the excess violence. Law says possession is the guarantee of facts. It amounts to evidence of ownership. Finder of goods becomes the owner against the whole world except the true owner. So, where the title of the owner is imperfect, cumbersome, dilatory, inefficient, then possessory remedies stand in upper position. That means whether true owner lost his case, he has to forget his property? No. It does not mean law always protects the true owner. It does not mean that law always protects the possessor. It takes into account the proprietary remedies. The order has to show he is right, burden of proof of ownership with a perfect equity. So, prior possession acquires better title based on the maxim, he who is earlier in time is better in law. So, defendant is always at liberty to rebut his presumption and owner can get back the property. The end. Thank you.